It's Ron Coleman. The last time we did a law learning lesson, which was a while ago, we talked about counterclaim. So, as a brief refresher, a complaint is what starts a lawsuit. It's the initial pleading. And then there's the response to the complaint, which is typically an answer. It can also be a motion to dismiss, and we briefly discussed motions to dismiss. A motion to dismiss essentially says either the court doesn't have jurisdiction over the defendant, or that even if everything that were claimed about the conduct of the defendant, who the court does have jurisdiction over, even if it were all true, it would still not be a legal claim. Then we talked about counterclaims, which is where, assuming that no motion to dismiss is made, or that if one is made, it's not granted, the defendant not only answers the complaint, but also sues back. People often use the term a countersuit. Countersuit is not a technical term that we use. We call it a counterclaim. Now we're going to get a little bit more sophisticated, and we're still in the category of pleadings. Nothing has really happened in the case besides this side says this and this side says that. Well, there's another kind of pleading that can be filed by the defendant, and that is usually alongside the answer, something called a third-party complaint. Now, a third-party complaint used to be called an impleader. That term is not used anymore because it sounds too much like interplead, and interpleading is a different procedural action, which we're not going to get into today. But a third-party complaint, that is fairly clear language. What it says is, I, the defendant, believe there's someone who is not currently part of the case who is actually responsible for some or all of the plaintiff's alleged damages. Essentially, the defendant is saying, if I'm liable, then this third party should be held responsible instead. One common reason to bring a third party defendant in is if there's an agreement between that third party defendant for indemnification. Let's say there's a contract, very common for indemnification to be provided by contract. And in an indemnification agreement, such as often exists in a commercial lease, one side, usually the side with the superior bargaining power, says, if I get sued over this, you are obligated to indemnify and hold me harmless for any damage that might arise because of this lawsuit. Why would you agree to that? Again, usually because you don't have a choice. However, I will say that if you are negotiating a contract, obviously if you have a lawyer, he or she knows this already, and the other side wants an indemnification provision, it's usually not that hard to get rid of it because it is such a potentially ominous and harmful provision. Again, if it's a sophisticated commercial relationship, you might not be able to get rid of it. But sometimes people just throw it in there. If there's any way to get rid of it, you can. There are also indemnification obligations that can arise under the law where there's no agreement, but where the law says in such and such situation is always the case that person with relationship, if Y is sued, then X is obligated to indemnify that person for any damages. What third-party complaints do is make litigation inevitably more complicated, unless the third-party defendant is merely an insurance company. That is sometimes the case, in which case it may or may not make that much of a difference. But it usually makes things more complicated. You remember that the third-party defendant now has an opportunity to answer, to make a motion to dismiss, or potentially to bring in other parties. So it can slow down the litigation considerably. It is usually likely to complicate the litigation, but we do live in a world that is complicated, and sometimes the relationships, the legal or commercial or personal relationships among people, will make litigation even more complicated, even more costly, even less predictable than you might have thought when you first decided to sue someone for something. These are, for all practical purposes, however, possible pleading responses. Complaint, response to a complaint, which can include a motion to dismiss, an answer to the complaint, and an answer combined with a counterclaim, which is the countersuit, the lawsuit against the plaintiff. You can't fire me, I quit. You sue me, I sue you. And the third party defendant. Those are the, for all practical purposes, possible pleadings that can begin a lawsuit. So this is a short return to our law learning lessons, but I thought it was a good one to jump onto because it's simple and it does exhaust the pleading stage so that we can get on to the next fun and exciting part in our exploration of this esoteric, expensive, and annoying part of human life. Talk to you again soon.